Hey, how are you beautiful tubers doing today? I hope you're doing well, very well. We have a new, latest, greatest, whatever it is, filing in the ongoing saga of Jeremy Hales v. Preston and Cook. So let's cover this. First of all, what I want to do is, I want to show you guys, this is a 12B1 hearing, okay? So, Rule 12 of the Federal Rules of Civil Procedure says defenses and objections when and how presented, motion for judgment on the pleadings, consolidating motions, waiving defenses, pre-trial hearing. So it's a 12B, little b, right? So go down here, little b. How to present defenses. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by motion. 1. Lack of subject matter jurisdiction. That's what we have today. That's what this reply is. 2 would be like a personal jurisdiction. So subject matter is mountain controversy, $75,000, and diversity of citizenship. Like a personal jurisdiction is when it's a constitutional question, or it is between the state. No, the states is Supreme Court. Sorry. Anyway, it's a constitutional question. 3, improper venue. Improper venue would be that it's filed in the wrong federal district. 4, insufficient process. Process it. You didn't, in service of process, I always think they're the same thing. You didn't serve the person. They haven't had their right to, they don't know the trial's going on. Yeah, that's actually a big thing. It used to be huge that they would file a suit and then not tell the person they're suing and then get a summary judgment against them. 12B6. Failure to state a claim upon which relief can be granted. That is my favorite one. That's why I wanted to get through to 6. So, you guys still there? You still with me? You know what's happening? Are we happening? Are we cool? Are we groovy? Look at that. Hey, I just made myself a little bit bigger. So, what we're going to do is we're going to read this. Oh. Didn't do that one right, did I? Let's share. It's been a while, y'all. It's been a while. I'm a little rusty here. A little rusty. Have the 3D world's kicking my booty. So this is the 87th document filed in this complaint. It sucks, right? It sucks. Yes, I feel like I'm coming out of the screen a little too big. Never mind what I was gonna make. I'll tell you what, how about this? Let's get rid of this up here. You guys, please subscribe, hit that button, you know, all that good stuff, all that good groovy stuff. Let's do this. And we're gonna move me to the top right where I like to be. Always turn the pot to the right. So, reply to plaintiff's 12B1 opposition. The court has already determined that the original demand was made in good faith. Plaintiff 12B1 opposition, document 80, page 3. This is false. That's what we're going with already. We're going to go, this is false. The court determined that the amount in controversy satisfied the jurisdictional minimum under 28 U.S.C. 1332. That's the $75,000. In reliance on A, the plaintiff's contrived extortion claims giving rise to treble damages plus attorney fees. B, the statement in the plaintiff's affidavit, document 8-1, paragraph 19, the defendant's online post calling me a child predator are constant and ongoing to this day. And C, the allegation of using defamatory statements to influence customers as the court has come to learn. A, the extortion claims are interposed without basis in fact. C, document number 63, dismissing extortion. B, the statement in paragraph 19 of the plaintiff's affidavit was falsely interposed to influence the outcome of the prior 12B1 motion. And C, The plaintiff's allegation defendants use their defamatory statements to influence customers doesn't allege any additional actions. I don't think that's necessary. I don't know. I'm being a little snarky with this. Okay, I am. I apologize. But this is the 87th freaking document for a guy who's doing this pro se. I don't believe it at this point. I'm sorry. Somebody's paying somebody. All right. Dude, no attorney worth their salt is going to be doing this for free. That's just dumb. How stupid would you be to do it for free? Nobody does stuff for free. Sorry. That's all in movies and make-believe and fantasy land. Chutes and ladders and whatnot. Candyland. There is not, nor was there ever, the possibility of recovering $75,000. The plaintiff clearly invoked federal jurisdiction in bad faith. Now, this is a play on words. There is not the possibility of recovering $75,000 because they don't have $75,000 worth of assets. So technically, he's saying the truth. But that doesn't mean that there wasn't $75,000 plus worth of damages. You're filing for damages, not what you can recover. All right, B, the plaintiff's memorandum, document 80, states on page 5, regarding the motion's claim that plaintiff cannot identify a single person who saw the defamatory signs other than Zim, you made me hiccup, Paget, Teresa Granger, or Stephen Granger, the defendant's counsel, I got the hiccups, wonderful, disproved this himself recently in the deposition of Miss Amanda Martin, defendant Preston's court-appointed victim's advocate. I don't know who these people are. An employee of the 8th Judicial Circuit of the state of Florida who testified that she saw the signs when social media posts and links to these defamatory signs were sent to her by 2 different people via email. See transcript attached as Exhibit 2. This distorts Miss Martin's testimony. The motions claim that plaintiffs cannot identify a single person who saw the defamatory signs other than Zim Paget, Teresa Granger, and Stephen Granger. Refers to page 9 of defendant's memorandum, document number 68. The plaintiff admitted in his deposition he can identify a single person who saw, understood it, and believed the signs. Question, can you identify the person other than Zim Paget, Teresa Granger, or Stephen Granger that saw the signs as they were posted? I don't think this matters, okay? You had the intent. You had the intent to put something out there with no focus on the repercussions that it could happen. Maybe nobody saw it. Maybe 1 million would see it. There was no controlling factor in how many people saw it. It doesn't have anything to do with your mental culpability that you actually meant to do this. It's like conspiracy is one thing. The only thing I can think of is to relate it to a criminal complaint. Okay, so it's like a conspiracy, or it's like, you see a movie and they planned out how to do the perfect crime, but they never do the crime. Was a crime committed? Well, it depends on how far along they got in that crime. Maybe Joe Blow planned the perfect crime, told somebody about it, and that person went out there and did everything relying upon Joe Blow's, statements, or was going to be there, or something like that. Joe Blow may be a conspirator. He may be liable in some way. I mean, it's just, you don't do an intentional act unless you're prepared for the consequences. I may go flush the toilet. I don't know. Maybe the toilet overflows. What do? Turn the water off. I mean, you have to be prepared for any act. Every action has an equal and opposite reaction. I am a Newtonian, but obviously I'm also just bumbling. Isn't that right? The plaintiff leaves out as they're posted to mislead the court and believe that Ms. Martin, seeing the signs on YouTube, somehow supports the plaintiff's claim. It actually does. It is a sign in the public, out in the public, displayed on YouTube. Shocking. I don't think... This is how you know that somebody's being paid. Nobody's coming up with all this stuff just because, oh, I'm a social justice warrior. Social justice warrior for the turtle conundrum. Stupid. YouTube somehow supports the plaintiff's claim. In fact, the plaintiff admitted in his deposition to knowing of nobody who saw the signs as they were posted. Three people that found them. If anybody else comes forward, I will name them. But he hasn't named anybody. C, the plaintiff states on pages 5 through 6 of document number 80 regarding anyone directly contacting Whatnot Incorporated to use defamatory statements to interfere with plaintiff's relationship with Whatnot Incorporated. Again, defendants counsel has recently provided such evidence. This occurred Monday, February 17, 2025, when defendants counsel emailed Mr. Cam, a Whatnot Incorporated representative. Who the hell's Mr. Cam? I mean... what does that have to do with anything? I don't think this is how this works. Okay, I'm probably very, very wrong, but I don't think this is how this works. Followed by excerpts in the email in question. Besides the the guy's not under oath. You're just asking some jabroni named Cam. Is that right? Is this made up? I don't know. I've been under a lot of stress lately. Maybe I'm completely bumbling. Besides the plaintiff's tactic admission of having no other evidence to support his claim of interference, the undersigned did not email Whatnot representative Mr. Cam. Supporters interference, the undersigned did not email. The quoted email was to plaintiff's counsel in response to an email. Holy God, what are we reading here? From the plaintiff's counsel that he sent to Mr. Cam and inexplicably CC'd the undersigned. Inexplicably? Really? About the confidentiality concerns. The plaintiff's memorandum omitted the beginning of the undersigned's email to make it misleadingly appear that the undersigned independently contacted Mr. Cam, but the undersigned's reply all was to Attorney Shockett with automatic CC to Mr. Cam, and his reply email addressed Mr. Shockett, but not Mr. Cam. Oh my gosh, dude. This is just put in here. This is a motion for YouTube, y'all. This isn't real. This isn't real. This is put in there because so many people are trying to grift off this. And the best thing to do is, I think we all just probably need to stop talking about it. That's probably the best thing to do. If there was no attention, there'd be no more of this. Mr. Shockett, I do not know what machinations you are orchestrating by copying me on this communication. I have no obligation to provide a proposed order of confidentiality, although I did specifically provide a stipulation to maintain confidentiality in writing. But you ignored that because your purpose has been to exploit the issue of the production of this contract for as long as possible in order to waste time and create issues for court motions to generate YouTube content. Holy hell, run-on sentence. Is there a period anywhere in here? I have no obligation to provide a proposed comma. Although I did underline did specifically, comma. That is one big run-on sentence. No wonder it's so bumbling. And I love that we're getting the thesaurus out to try to get people to mess up their words. So great. D, the plaintiff and his counsel accused the undersigned of fabricating a quotation from legal authority, going so far as to reprint the entire 2 pages of a U.S. Supreme Court decision, Rosado, they claim was falsely quoted in the defendant's memorandum, see document 80, pages 7 through 9, concluding defendants have obviously fabricated these phrases from whole cloth while presenting them as purportedly being from the United States Supreme Court opinion, Rosado. Exceptionally, defendants' use of the quotation mark misleads the court into thinking that this is a direct quote from the cited opinion. This will also should not be well taken. The alleged fabrication. What does this have to do with the 12B1? What does this have anything to do with 12B1 at this point? We have completely wandered off the course. Here's the path. Here's where we are. We're just kind of like all over the place. This is schizoid. This is schizoid. Oh my gosh. Look, this is fine. Okay, if you have a problem with it, that's fine. But I don't see what this has to do with 12B1. Right? Defense's objections, when and how presented. Motions for judgment. 12B1 says how to present defenses. Every defense to a claim for relief in any pleading must be asserted in the response of pleading if one is required. But a party may assert the following defenses by motion. Lack of subject matter jurisdiction. What does this everything have to do with subject matter jurisdiction? That's it. That's all it is. Maybe I'm wrong. Let's continue reading. And I apologize if I am wrong. Okay, I apologize for this whole thing. I apologize for reading this stuff. I apologize for you guys being here. But hey, we just pretend we're all eating sexy bacon. The alleged fabrication is, in fact, direct, exact quote from the Shanahan decision, which is cited following the quote. But it's not, though. It's okay. The Shanahan decision is quoting Rosado. You go back to the actual quote. You go back to the original thing because we don't know what Shanahan. We don't know what that has to do with this. Okay, Rosado may have something to do with it. Shanahan doesn't. So just because the court is using a line, like it's like court always puts in their lines like to whether or not this is it has standing. Standing is a big one. Okay, so whether or not the court has standing to hear the claim, it's always usually there's a quote. It's blah 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 citing whatever Supreme Court case is the popular one on standing, and there's ones that follow it, but they're always it goes back to the same thing. It's like freedom of speech is always like goes back to like the lemon test, right? I mean, it's just I don't know. It's just. This is not, you're supposed to write law. Like if you're making legislation, you're supposed to write it in clear, concise wording. So that way there's no ambiguity to it. This is a very ambiguous, this writing has a lot of ambiguity in it, which is something that is distinctively lawyerly. This is why I think so many channels are getting a lot of this stuff wrong. The defense has gotten some things very, very right. And the plaintiffs have gotten stuff very, very right. But it's okay. It's okay for some to be wrong on things as everything else because it doesn't. Although it doesn't matter. What's the point here? What we're trying to do is just keep this out of court, saying that there's not subject matter jurisdiction. So this whole memorandum here is to support the claim that there is not $75,000 to avail There's no cause of action, which this should be a 12B6. I don't even think this is the right pleading. I think 12B1's the wrong pleading. It's not subject matter. I think it's a failure to state a cause for which relief can be granted. Watch and see if they don't make an amendment. See if the defense is making a 12B6 amendment. If they do, I better get credit for it, okay? I don't want one in a federal court case, okay? I don't want any credit there. I want all you little, I want everybody on the tubes. You guys heard it here first. God, my life sucks so bad right now. If you guys only knew. The stuff I gotta go do. Let's see here. So where are we? Rosado, see page 68, 11, 12. The defense memorandum neither quotes nor independently cites Rosado, and there is no representation of any quoted language that came from Rosado. Oh, excuse me. So maybe they're saying that they didn't quote Rosado. Instead, they quoted Shanigan quoting Rosado. So maybe he's right. Maybe everything I just said there, I take all that back. It's up for you guys to decide. I'm reading it. It's just opinion. I did describe it, though, properly in the viewpoint that I saw it as. But to further the false accusation, the plaintiff leaves off the last sentence of the quote from the defendant's memorandum as well as the Shanigan citation itself. In particular, it is important to consider, by the way, this is not how you, I mean, you did it like here, this is how it should be. Anyway, in particular, it is important to consider whether the amount claimed in the complaint was made in good faith or whether plaintiff was consciously relying on flimsy grounds to get into federal court. I don't think that's a possibility with a practicing attorney. The attorney, so this is an attack on Shockett, because your attorney should say whether or not you have, you have a claim. It's their license that's on the line in all this. They're the ones licensed. You aren't. Usually they go, yeah, it's $75,000. And you'd be like, nah, man, it's just busted down VW. It's not. Anyway. This is just flimsy grounds for whether they're getting into federal court. Distinguishing initials and substantiality for subsequent mootness. That's omitted by the plaintiff, was insubstantiality for subsequent mootness. Doesn't apply. Another critical equitable factor is the, I love the use of equitable when you're not talking directly about money. It means another meaningful factor or another important factor would be the easy way to write this. Is the existence of any state limitations bars to refiling, in the existence of any state limitations bars? We need to proofread, or you look like you're bumbling. To refiling in state court. See Ridenour v. Andrews Federal Credit Union. The undersigned does not fabricate legal authority and has never been so falsely accused in 27 years of litigation practice. Only the plaintiff's accusation is fabricated. Well, either they're accusing or they're not. I don't think that's a tricky sentence. But another critical equitable factor is the existence of any state limitations. Well, is this the part that was omitted? State limitations don't apply here. I mean, oh my gosh, even if that was a federal court ruling in 1970, I can't imagine that still standing today. It's, I mean, I guess so. I can see that, yeah. But it's a finite reasoning. This isn't, I don't know. How many pages are there? 4 of 6. Jeez. To bolster the false claim of fabricated quotation on pages 9 through 10 of document 80, the plaintiff rehashes a prior, also false, accusation that the defendant cited fake authority in their prior 12B1 motions that were filed pro se. Moreover, this is not the first time defendants have done this. While attempting to argue the minimum amount in controversy, defendant misstates and misrepresents the law in this court by citing to an opinion which does not exist, quoting the plaintiff's own response to the prior 12B1 motion. As known to the plaintiff's counsel, there's no citation to an opinion which does not exist. Oh, jeez. I mean, it's just a freaking. Is this what they're arguing about? I mean, because. Oh my gosh, I couldn't handle it. I could not handle this. I mean, this is why I don't practice. This is why I don't practice. As known to the plaintiff's counsel, there's no citation to an opinion which does not exist, but rather a miscitation because there are two reported decisions from the same case, leading to an honest mix-up. The defendants filed a correction of citation, document number 10, to directly address the error and clearly clarify the correct citation. Dude, I mean, can you imagine you're sitting on a law firm and you've got to go back to document 10 now and reread it and make sure, like, okay, where was this? Where are we? Nevertheless, as if document number 10 did not exist, the plaintiff misleads the court that the defendants fabricated authority. These little stars here, man. Like, this is like how you end a play or a script. You do, this is like to indicate the end of a document, not the end of not a different paragraph. So weird. I gotta find my blue book. God, I gotta find my blue book. I'm gonna start grading these things. The plaintiff no longer claims a minimum amount in controversy of $75,000. The plaintiff's 12B1 opposition does not attempt to argue that there remains a $75,000 minimum amount in controversy. I think somewhere it's up to the court. Once the court accepts it, the court has to find it. Once it's accepted. I don't know. Don't quote me on that. So this is, let's see. Moreover, the plaintiff's counsel emailed February 24th admitting in response to a document. That was yesterday, wasn't it? The 24th? To document a request for evidence of the plaintiff's lost income that damages were purely speculative. There is no such evidence at this time, as it will require an expert who is being retained. His report will be the evidence of lost profits. I mean, that's how it works. So this is how a small business works. I mean, you cannot predict. Okay, here's a big thing. It's like, oh, lawyers, they make so much money. No, they don't, because you don't know. Your paycheck is dependent upon who comes in the door. So you don't know if you're going to make any money that day or not. So everything is speculation. Now you can take profits from previous years and you can come up with a idea of what projected profit should be, but you don't really know. For instance, I'm not streaming right now. That was not projected in my income. So that gets washed out the door. You have something happen. So let's say like you fall off your motorcycle because you're cool, you're having your midlife crisis, you're the attorney, your name is something. Whatever they call each other now. I don't know. I'm not involved in all the drama. So you're out here doing your thing, and then all of a sudden, bam! You ran into a turtle, you flipped your bike, and you're in the hospital. You're not making money. I mean, you might have insurance that covers lost wages, but still, you're not making money. So there's the whole point to it. So instead of trying to justify interposing factual baseless extortion claims and submitting an affidavit. Oh, did I get this right? Yes. No longer claims, but Oh, yeah, sorry. I went down to read the thing. Sorry. But rests on the absurd, unsupported notion that once a plaintiff hoodwinks. What? What? Did I miss something here? Did I miss something? The plaintiff's 12B1 opposition does not attempt to argue that there remains a $75,000 minimum amount in controversy. Okay, that's when we went and read the sub footing. But rests on the absurd and unsupported notion that once a plaintiff hoodwinks the U.S. hoodwinks. I like that. I don't think I've ever seen hoodwinks. Isn't that the gerbil in South Park? I think that's the gerbil in South Park. Once a plaintiff hoodwinks the U.S. District Court to exercise federal jurisdiction, the court may not later dismiss the case, but must allow the abuse of federal jurisdiction to continue even after finding that it invoked in bad faith with contrived, baseless claims. Instead of trying to justify interposing factual, baseless extortion claims and submitting an affidavit with a false statement about online posts calling me a child predator to influence the exercise of federal jurisdiction, the plaintiff's opposition ludicrously and falsely asserts that the cited legal authority, Shanigan, supported dismissal of cases like this, concisely relying on flimsy grounds to get into federal court, is fabricated. Dude, you admitted that your clients made the signs. Like, you've got a problem with that. I mean, they intentionally went out to do this. If somebody intentionally went out and made signs and posted them all around where you lived, that you were a diddler. Let me just rephrase this. This is in the swamps of Florida, okay? People go for walks and don't come back in the swamps of Florida. You know what I'm saying? I mean, this is something that it could cause, this could be life-threatening. Making these types of allegations about being a child predator could be life-threatening. That is the worst thing in the world. The fact that anybody would defend somebody that's out there making those accusations is as bad as defending somebody who does those things. That's my opinion. And I'm an idiot, so don't pay attention to me. Come up with your own opinion. Critically think for yourself. This lawsuit has consumed, this is in conclusion, okay? No stars, just conclusion. The lawsuit has consumed the court's time and defendants' lives for long enough. The plaintiff cannot meet the jurisdictional minimum. The plaintiff abused federal jurisdiction. The plaintiff tries to again mislead the court to overcome dismissal. His lawsuit should be dismissed at this time. Usually on a conclusion, you want to wrap it all up back into that 12B1 that you're talking about. Last sentence should be that there is no subject matter jurisdiction. Anyway, that's just my humble little silly thoughts. Apply to plaintiff's motion. Plaintiff's opposition. Oh my gosh, dude, it's just... All right, there you go. We read the latest one. I was a little mouthy about it. I know. I'm bad. I apologize. I suck at this. Don't listen to me. Go listen to somebody else. Go listen to somebody who didn't torture themselves with law school, didn't sit in a law office and go, why am I here? Go do that. But I'll tell you what, anybody, there's nobody, this is not They're not doing this for free. There's no way. There's no way in the world, man. This takes. Do you know how much time this takes to do? I mean, it's ridiculous. I'd like to know how much a practicing attorney would bill out for all this stuff. I mean, not money wise, not cash, but how many hours? And you figure, like, I don't know what an attorney costs now. Federal attorney, I think somebody said it was like $400 an hour. Man, that's a lot of freaking money, man. That's probably like $56,000 or something. Who knows? Anyway, guys, you be safe. Love each other, okay? Again, I continually pray that this thing we just come to an amicable end, and they never see each other again. We never have to hear about it again. The end. In the meantime, be safe, okay? Don't fight with each other. Don't cause drama. Don't do all this stuff. Don't start screaming at each other. God, man, I turned YouTube on. I haven't listened to YouTube in a couple of days, and the first thing that pops up, somebody's screaming at somebody else. I'm like, you guys gotta stop this, okay? Because you know what? We're all on the same rock. We only get one chance at this thing. So, guys, please be sure to subscribe. Please be sure to hit that thumbs up. Share this, and send it out. You got your social media, you got your things, whatever you do. Print it out, put it in an envelope, send it down to Aunt Petunia. That said, Godspeed, everybody. Be good.